Kia ora, everyone. We'll just wait for people to jump onto the link and then we'll get started shortly for today's webinar. While we're waiting for everyone to jump on, you know how this goes. Usually I sit here and yarn a little bit. So I thought today we'll have a chat about something interesting that I actually read yesterday, which was around people applying for roles and maybe what the new generational divide, how they're actually applying. So looking at Gen Z and things like that. So if you're jumping onto the link now, don't worry, you haven't missed anything. This is more just me having a chat for the next couple of minutes while people jump on. And yeah, no, the article was really interesting. It said that a lot of employees, especially Gen Z employees, are actually looking at potentially using TikTok or they have been using TikTok to source their next role. Now, I wonder how much that actually applies to New Zealand and its landscape. It seems very American, right? For people to be on TikTok kind of jumping in and using that as their mode of applying for a role. But hey, that seems to be where we're kind of headed. So it'll be really interesting to, watch the space and see where things unfold. But yeah, it was a very interesting article. It showed a lot about the generational shift and the fact that a lot of Gen Zers are actually just jumping on and a lot of employers are actually jumping on TikTok to find employees. So it'll be interesting to see if you've got the chat down below. So absolutely use it. Give me your opinions on if you've kind of seen this space moving in New Zealand, but I haven't personally seen anything too much. But yeah, no, it was a fascinating article. And with us with releasing Smart Match and things like that, we still believe that it's kind of following the journey of the candidates and the experience that they actually go through. So it's quite wonderful. But yes, it's absolutely weigh in. You've got your little Q&A down below, so absolutely do. And what I'll do is I'll give it another minute or so and then kick things off. We've got a big webinar actually today compared to what we've done last year, where we've spoken about kind of, potential Holidays Act changes and things like that. This webinar is going to be completely different because last year really shook up the personal grievance space and the Employment Relations Act, and there's a lot forecasted for this year. So we will have a look at all of that and break all of that down, but please go and grab a drink, get a coffee, a tea, whatever tickles your fancy. It's almost lunchtime, so whatever you want, and then we'll get started shortly. All right, so we're 3 minutes in, everyone. So while you're grabbing your drinks, I just wanted to give a little bit of an introduction. Kia ora, everybody. My name is Sanam. Thank you so much for joining us today on our New Zealand Employment Law Forecast webinar. This is all about navigating 2025, and I've got Bernie in the background, off camera and on mute. She is going to be there to answer all of your logistical questions. But the cool thing is that she is the one that put together the fact that this is a forecast, and it absolutely is. It's us talking about essentially what's lying ahead for New Zealand and what we're going to be seeing as the landscape and the space changes. And it's going to change a lot. One of the things I did want to say is a little bit about me. Now, you must have heard my voice to death by now and seen many of these webinars because I've been kicking around at Employment Hero for the last couple of years. And I am the employment counsel here. I'm the in-house employment lawyer, and I work and live out of New Zealand. So I absolutely understand employment law inside and out in New Zealand. And I also practice across Australia as well. And because I live and breathe all of this, I also run a podcast called Employment Law Done Right. So I absolutely love the idea of helping employers out there navigate their businesses, making sure that they keep their compliance in check. And that's what Employment Hero is all about as well. So while we're getting everybody jumping on, I'll kick things off, do a little bit of housekeeping. I just wanted to say that don't worry, you don't need to be frantically writing anything down. We are going to have all of this recorded. There's also a Q&A portion at the end, so please ask your questions. I love answering them. I love hearing what you're dealing with in the workplace, and make sure that you send them on through so that we have that portion at the end to answer your questions. I'll try to get through as many as I can, and then we'll see with the post-webinar materials when we send through the guides and fact sheets if we'll send through some of those answers as well. Now, before we fully kick things off, I always have to do this. I always have to give my little disclaimer. So I just wanted to say that, oh, this is me, by the way. Welcome. welcome. I just wanted to say that, look, this is all information that's provided to you in good faith. So if you are dealing with anything in particular in the workplace, then the good news is that we actually have rolled out our HR advisory line, which is available to New Zealand clients and customers. So absolutely tap into that. Otherwise, if you're not already a customer, then contact our team. We'll send through post-webinar materials and you can absolutely speak to them. And last resort, go and speak to a lawyer in your area if you're dealing with something in particular. So we'll get things underway because we've got a lot to cover, as you can see. We've got personal grievance thresholds all the way through changes to exit discussions, restraints of trade, and the Holidays Act makes an appearance again. So we'll be discussing all of that. And I just want to say, before we fully get into this, there is a lot of changes here that are being proposed, and that is mainly what we're looking at. It's proposed changes, except for the minimum wage increase. Everything is going through the houses. It's basically at a bill stage at the moment, so it's proposed, and it will either, make it through and be enacted into law, or it might get dropped throughout the process. But we definitely have seen a push from the coalition government to move these things ahead. This is part of their agenda and what they want to move ahead. So with that said, I just want to say, do not shoot the messenger. A lot of these are controversial, but I am here to just relay the information out there. And absolutely, if you want to get into a little bit of discussion or anything around it, then reach out to me on LinkedIn. I'll have all my details at the end of the webinar for you to have a look at. So we'll kick things off by looking at the personal grievance threshold. Now, first things first, all of these changes that I'm going to mention until I move on to looking at minimum wage and pay secrecy, all of those are related to the Employment Relations Act. So this is all about amending the Employment Relations Act and changing it in a way that will actually make things a lot easier for employers. Now, again, it's quite controversial, so we'll have a look at what's actually going to be changing, because it hasn't sat right with a lot of managers that I've spoken to, a lot of employees out there, and rightfully so. So the first thing that I wanted to chat about was actually introducing a $180,000 threshold. So basically what this means, tail end of last year, I believe it was around December 16, 17, somewhere in that range, the coalition government loves to do an announcement right before Christmas. And this was just like we heard about the trial periods. This was one of the same things. We saw that an announcement came through tail end of last year, and it was about the fact that personal grievance regimes are going to change significantly. And what we mean in the first part of the change is that if this goes ahead, employees earning over $180,000 annually won't be able to raise a personal grievance for unjustified dismissal. So they absolutely can raise personal grievances for other reasons, other types of grievances. So for example, discrimination, sexual harassment, things like that. But if it is unjustified dismissal related, then if you are earning that 180,000, then yes, you are not able to raise the grievance. Now, when you look at this landscape, let's give a little bit of context as to why this exactly is 180,000, what the reasoning is, and all of that. So the government kind of set the scene. They set up their reasoning and they said, look, at the end of the day, we're looking at a small percentage of the New Zealand population when we're looking at 180,000. They put the ballpark figure between around 2 to 3 or 3 to 4%, somewhere around there. And they effectively said that the reason why they're targeting these $180,000 thresholds is because these are the employees that are senior leaders in a company or in an organization. So their ability to uplift morale, to have a cohesive team, that is a really big thing for businesses, because at the end of the day, if they're not performing well as a leader, and if they are impacting business-wide different teams and even their team immediately, that is a huge issue. So at the end of the day, we have to have a look at kind of the balance of this. And in these particular cases, these employees are generally the ones that would have a lot of weight in the workplace. And that's why this has been introduced as a way to help underperformers and to be able to have frank and open discussions with them. Now, What's really interesting is we've already seen other countries implement this. So Australia already has something very similar. They've had it for many, many years now. There has been a lot of discussion online around whether this is going to cause a huge issue when it comes to discrimination cases. Will people try to frame their personal grievances in a different way? So let's say if they're underperforming, all of a sudden, if you're trying to move them on and exit them out of the business, then they say, well, actually, it's about you discriminating against me. It wasn't actually about my performance. To be honest, this hasn't come up too much in the Australian space from what we can see. A lot of times employees understand what they're getting into, and that 180,000 in Australia or in New Zealand, sorry, that will be the whole idea will be to have an open and frank conversation with these employees. So to be able to sit down and say to them, look, these are the areas that we're finding problems in. How can we move forward from this and how can we work together? And to be honest, I've practiced across Australia and New Zealand. And I've been heavily involved in those discussions when we're sitting down with an employee and chatting to them about that. And it can actually be quite beneficial for a workplace because it allows for a more open discussion. You just kind of pack up and then you go, all right, how do we fix this and how do we move on? Rather than saying, you're fired or looking at it as a more termination route. So that's where I think that this will be quite beneficial. But again, there's a lot of controversy around this just because of the fact that it doesn't fit in with the Employment Relations Act, right? It does not fit in with our standard approach of good faith and the way that we have approached employment law to date in New Zealand. And the interesting thing, though, is that employees can actually voluntarily opt back in. So employers and employees can do the same thing. They can agree, they can bargain and negotiate and have that clause added back into the agreement. The concern with that, though, and what I've seen online, and it's a lot of discussion from lawyers, is will this cause unfair bargaining? Will this cause an issue around the employee saying that, they were kind of coerced or they were pushed into not having this in there or whatever it may be. So that will be interesting and we'll kind of see how that discussion unfolds as we go through. Now, a couple of announcements that actually came out last week. So this is, hot off the press. We've got it here for you first. If you haven't seen it already, Minister Brooke van Velden, who's the workplace safety minister for the coalition government, she basically sat down and gave some further information around the $180,000 threshold. Now, one of the things I wanted to mention, I don't know if I mentioned it already, it's $180,000 annually that the salary is, but that is the base salary. So that is what you're going to have in your remuneration section of the agreement. It's not going to include any allowances, any bonuses, or anything like that. It will be 180,000 base. Now, the announcement that was recently made is all about the employment agreements and how this applies, because everybody always has questions around that, right? What happens in these particular cases? So it will apply to all new employment agreements. So usually what happens is the agreement that when a new law passes, they don't try to just apply it retrospectively to everything because it can create so much tension, confusion, and it wreaks havoc on a workplace, right? So what they have decided to do is for any new agreements, it applies immediately if the law gets passed. And then for existing agreements, the change won't take effect until 12 months after the law passes. So that means that anything that you've already had in place, it will kind of run its course. And in the 12 months, you might have some bargaining that might happen, some discussions with your employees. To be honest, this is not enough information right now to go off of, but I'm sure that there's going to be a lot that's going to come out of this. How do we approach our employees? What do we discuss with them? So once we see more of that bill and once we see the law kind of coming to fruition, then that's when we're going to be able to actually hone in and say this is the exact process. And obviously, we need to see test cases as well. But generally, you'll have that 12-month period, except in the cases where the employee moves to a new employer or that they change roles with the same employer. Now, changing roles is tricky. We know how that works. You might vary someone's role in the workplace. I'm assuming, and I know it's not good to assume, that it's going to be a full-on change where maybe, you're going from a barista to a head chef or something like that. But we just don't know right now. Obviously, the barista to the head chef won't be earning 180,000, but it just as an example. So we'll see how this kind of unfolds. But that is the main crux of the change and what we're seeing kind of playing out. But again, we just don't know until we see more information being released about this. And this is what we know so far. So we'll talk about the next point now, which is exit discussions. So exit discussions are very interesting. I'll give you a bit of a background about what I mean here. It usually, in most scenarios, when you have a conversation with an employee, when there's a dispute or an issue in the workplace, let's say they've raised a personal grievance, or even short of that, let's say the employee saying that this is untenable, I don't want to work here anymore, and they might kick off a dispute, or you might have a disciplinary process and you might want to have an off-the-record conversation. Usually those off-the-record conversations, in New Zealand we call them without prejudice conversations, and what it effectively allows you to do is have a conversation with the employee that is off the record, where you sit down and you have a chat and say to them, look, we understand that this is not working out, or that there's this particular grievance, afoot, or whatever it is. And because of that, we'd like to have a look at settling this dispute or this issue for a sum of money, compensation, and some other terms that you might want to put in there as well. Now, the reality of these kinds of discussions is unfortunately that right now, if you offer an exit settlement, then it could actually give rise to an unjustified constructive dismissal claim. And what that basically means is that the employee could say that the business forced them to resign, or that they felt like they had no other choice but to resign. I know I've unfortunately in my time seen some employers, basically give employees ultimatums around this, and the employee feels like they're backed into a corner, so they resign and then they raise that constructive dismissal claim. So currently that's where the law stands. And now with this new termination and exit kind of discussion bill that's being proposed, where you can have these conversations, if this goes ahead, what it will actually allow an employer to do is have a very frank and open conversation with the employee, where they actually are discussing an exit settlement without worry of ramifications or a constructive dismissal claim. Now, I'm going to be honest, as I was working through these slides and everything, and like I said, I mention things in my podcast all the time. When I was working through it, one of the things I thought of was, let's look at the reality of this in the workplace. It'll be interesting to see how this kind of progresses, because at the end of the day, any exit discussion with an employee, the employee now knows that you want them out. What happens if the employee says no in that conversation and they don't want to be exited out? They don't want to be moved on. They don't want to reach a settlement. Then what happens? Because at the end of the day, yes, they cannot raise a claim. You can have that discussion with them. You can have it off the record, but now they know that you don't want them in the workplace. So because of that, I would say that this is going to be one where you've got to use it with caution. At the moment, we don't have enough information, a whole breadth of information around this, where I can definitively say that, look, you're going to be safe with this, this, and this, and you're not going to have to worry. So we'll see how this, all pans out, but watch this space, because it is an interesting one, and this can really change conversations in the workplace. Obviously, you're going to use it with caution, but it will allow you to at least start having these conversations rather than always being in fear and only having them maybe when you've got a really nasty curly situation, or when you're dealing with a full-blown personal grievance. So that is the next change to the Employment Relations Act that is being proposed. After that, we actually have the most, I would say this, probably this is the most second hot button topic, which is actually around the removal and limitations of personal grievance remedies. So what do I mean by this? I mean that what is being proposed here is that, look, if an employee contributes to their personal grievance, then depending on the level that they contribute, they might not get anything awarded to them in the end. So I'll discuss a little bit about what remedies actually are, just to give you a bit of context. I know a lot of you out there probably know what they are, but just in case, the Employment Relations Authority in New Zealand, who is normally who you go to after you try to settle at mediation, or the employment courts, which is your usual last kind of resort, and then you see bigger cases like Uber going there. They are the ones that have the powers to award employees with remedies. So some of them might be reinstatement, for example. It could be compensation to actually cover you off and to compensate you for any hurt, humiliation, any damages that you've incurred as part of this dispute or this issue. For the long longest time, what has happened is that if an employee contributed towards their personal grievance, usually the authority, the courts, they have the powers to actually limit the amount of compensation that the employee would get. Now, the limitation, it was only around 50%. And there were a lot of cases that I've personally been involved in. I've also read and seen about where an employee has engaged in serious misconduct, but because there were slight flaws in the process, or the employer might have, jumped ahead a little bit quickly, or even the employer tried to do everything by the book, but there were other factors that kind of came into play. The unfortunate truth at the moment is that there are many cases where the employee walks away still being awarded some money, even though they did commit particular things in the workplace like theft, fraud, maybe bullying, or all of those things. So that's where the space is going to change quite a bit. What the coalition government has proposed is that if there are cases of serious misconduct, so we're talking, like I said, theft, fraud, harassment, things like that, then they are proposing to remove all remedies, every remedy possible for somebody that is engaged with this. Now, let's play devil's advocate here, and let's be a little bit, a bit more honest about what this would mean. It would be important to really understand, firstly, what the parameters are around that and how that's going to be, kind of judged. And there's a lot of times when you have falsified timesheets, for example, and it's a bit gray. You don't know if the employee did it or if a friend helped them do it or whatever it is. I've dealt with those cases in the past. So that's where I would say that it's going to get a little bit interesting when we get into the gray. And similarly, if the employee contributed to the issue in the personal grievance. So let's say that they had repeated issues with their performance. And this is something that the coalition government and the minister actually really highlighted in their announcement. They've said that the employee will not be eligible for reinstatement or compensation for hurt and humiliation, which means that there is no more opportunity now for an employee to be constantly underperforming and for a personal grievance to kind of go through and allow the employee to be awarded sums of money. Now, again, with the repeated instances of poor performance, it's a tricky one. We don't normally associate performance with this whole idea of no pathway for any kind of recourse or anything like that. Normally with performance, the way that we say best practice is, especially in New Zealand, is that you're trying to work with the employee to get them on the right path. So this is kind of maybe going to be the middle ground of like you've helped the employee as much as you can, and the employee is maybe neglecting what they need to be doing in the workplace, not following management instruction, and therefore you're headed in this direction of, look, we've tried everything, and now when you go to the ERA, they end up saying, no, the employee is not eligible for anything. So it'll be interesting to see if it kind of works in the space that we're in. But so far with the best practice approaches that we do, it's kind of different to what this is being proposed as in terms of it being all about performance. So we'll see how that space kind of pans out. But again, it's an interesting one. And then the last one is around an employee contributing to the situation, giving rise to the personal grievance. So this is where we see a lot of issues, right? The employee doesn't play ball, they're constantly delaying processes, they might not be cooperating, that you're trying to give them instructions like go and get, a medical certificate or do this or do that, all of these different things, and the employee's just not working with the employer. That is where there's been a proposal of a reduction in remedies of 100%. So like I said, 50% was the cap before, and we would normally see, $20,000, for example, awarded to the employee, then cut down by 10, and then maybe they would get something else, on top of that. But this is completely different. This is going to be a situation where 100% of the remedies can actually be removed, and that is what is going to be completely discretionary when it goes to the Employment Relations Authority or to the courts. So watch this space. We'll see how it goes. Like I said, it's not palatable. I know this is a conversation where I like to be very frank about it. I've used that word many times in this webinar, so I'm sorry. But I understand that the reality is that this is not the space that we are usually in when it comes to employment law. And we are really shifting to a more, I would say, Australian kind of standard or Australian system with a lot of these things. So it'll be interesting to see how it works out in the New Zealand context. The last one that relates to the Employment Relations Act is actually restraints of trade. This one has been a topic of conversation for like 2 years because we've seen the bill kind of go. It's been progressing. A lot of people were umming and ahhing. I think I've been, like I said, at Employment Hero for just over 2 years, and I believe that this came out, a couple of years ago before I had left private practice. Everyone was like, "Whoa, this is going to be a game changer. This is going to be huge." But we've got a long road ahead, it seems. And with restraints of trade, you may be wondering, what is it? What's it all about? Well, effectively, a restraint of trade is a way to bind an employee to a particular area, a particular workplace, and basically stop them from working for any competitors. Now, why would you want that? It would be mainly to protect your legitimate business interests. So we're not talking about soliciting clients here or engaging with particular employees. These restraints that we're going to talk about are specific to this employee not working for a competitor. Usually the way that the contract will be set out, if it is enforceable, is that for a senior employee, you would say that, look, you can't work within an X amount of radius, so it might be 10 kilometers, for example, and then you might not be able to work for that competitor for about 3 months. And what's been interesting so far is that a lot of employers will put these restraints of trade in agreements. I remember I've had some in the past where the restraint was for all of New Zealand for 12 months, and I was just a low-level employee just living the dream. So absolutely, that would have been unenforceable. But hey, they gave it a try, so it was worth it. But no, it was very interesting, and that's usually the approach that I see that employers make, is that they'll put these things into the employment agreement without really thinking twice about it. And now what's going to happen is, if this law goes through, there is going to be 3 key changes that are going to be made to restraints of trade. The first one is that it's going to prohibit the use of restraints on certain employees. So like I said, this ideally should be used for a senior level employee, not somebody that is a lower level employee where you have maybe 100 different sales assistants, or you have 100 different, cafe staff that might just be waiters or waitresses or baristas. It's not fair to bind them unless they have some sort of sensitive information or knowledge that you need to protect legitimately. So that is where this bill actually proposes the idea of restraints not having an effect where the employee actually earns less than 3 times the minimum wage. So if you earn 3 times more than the minimum wage, then that is where a restraint of trade will be used. Again, there are still other components, and the next one is that an employer will have to pay for the restraint too. And this is where I really believe that it will be the sticking point, where a lot of employers will go, "Ooh, do I really want to do this? If I've got somebody on such a high salary, do I really want to bind them for this amount of time?" And effectively what this is saying is that employers will be required to pay employees who are subject to a restraint an equal amount to half of their weekly earnings. So that means that they're going to have to pay for half of their weekly earnings for each week in the restraint period. So while the restraint is in effect, and while you fully want them to be bound and restrained to your workplace, you're going to have to pay them half of their weekly earnings. And that's a lot of commitment, right? If you're looking at some restraints being 6 months, things like that, it's still a huge commitment. And the last thing that's being proposed here is that we say, the restraints, no more 12 months like I got. It will be 6 months at a max cap, and you're not allowed to go beyond that, because like I said, we see these massive ones where they're months on end. So these are the ones where I would say, look, we'll watch this space, see how it goes. This one's been kicking around for a couple of years, and there hasn't been significant amounts of movement since about the probably beginning of last year, but we'll see as this passes through what this will mean. But I personally have seen, like I said, employers incorrectly use this and then kind of get into a space where they believe that they are able to use the restraints when the employee is leaving, and it's a very difficult conversation to have. So it's a lot easier if there's parameters and guidelines set out, and for the longest time there hasn't been. We've been going off of kind of case law, we've been going off of previous examples, and that's why this is always a gray area. Lawyers love to say that we won't know until we take it all the way, or we go to the authority, or we go to the court. So these are one of those ones where I give that spiel. So yeah, so we'll go on to the next thing, and that is all about an update to the Holidays Act. Now, I just wanted to quickly stop by and say that we still have a long road ahead of us. It's back to the drawing board. Unfortunately, there was, and unfortunately, and maybe fortunately as well, because this has been an ongoing saga and we do need something simplified. But the coalition government basically came back and said, look, after doing all that targeted consultation that ended last year in September, there's still a lot of work to be done. We've got a lot to do. And basically what they're saying is that, look, simplicity is really, really important. And we've really steered away from that. We need to maybe take an hours-based accrual approach rather than doing it the way that we've been suggesting. So Bernie and I got together last year and we did an amazing webinar on all these Holidays Act changes and everything that you might need to watch out for this year. And unfortunately, that is now thrown out the window. So don't worry, I'm sure as this space changes and it unfolds, Bernie and I will be back again with another webinar for you all. But for now, this is unfortunately the space where we're back to the drawing board. But like I said, take this as also a benefit. The Act hasn't been changed in a long time. And if we're going to do an overhaul, then it will be good to see it being done right rather than creating more issues for everyone. So let's see how this goes. Don't hold your breath. But the coalition government has said that before their term is done, they want to make sure that there is a draft, a piece of legislation or a bill kind of passing through the houses. So we'll see if we get to that stage. Now, the last thing in terms of proposed changes and not necessarily fully into place is pay transparency and fair pay secrecy. You've heard it 1,000 different ways, a bunch of different times. It's the hot button topic at the moment. I even had somebody reach out this week wondering if I could speak about this particular topic because it is growing with so much momentum at the moment. And you may be wondering why. Well, it's because in New Zealand at the moment, we don't actually have anything that stops an employee or an employer from basically including a clause in the employment agreement where the employee is not allowed to discuss their pay. So employers they have free rein, they are able to include that type of clause in the agreements at the moment. And what we have seen is a couple of years ago, Australia enacted their legislation which said no, employees should be able to freely discuss their pay. They should be able to discuss everything around their remuneration, and they should not be barred or they should not be told that they need to keep it secret. And that's why pay secrecy has kind of come up. Now, in New Zealand, we've got the Employee Remuneration Disclosure Bill. That is also, like I said, a change which is proposing this whole perspective or idea similar to Australia, where employees are able to talk about their pay to their colleagues and mainly making sure that they can speak to them without fear of retaliation. So without fear that their employer is going to turn around and say, hey, look, you've had all of these discussions around, your pay. And at the end of the day, that's not okay. We're going to have to go through a disciplinary process, or you've breached X, Y, and Z in the contract. At the moment, though, one thing that I did want to preface is that a lot of employers actually don't include a specific, well, from what I've seen, a specific clause around pay secrecy in their agreements in New Zealand. A lot of times it's kind of a thought that comes up a little bit later on. It's not necessarily something that that they've thought about. And so at the moment you can absolutely include it, but it is something that's quite rare. Usually there'll just be like a catch-all thing of like, you follow confidentiality, you keep all your, employment information confidential, but nothing that actually targets pay secrecy. So if you are anyone that wants to actually focus in on that, then you can have a clause in the agreement, and that is the only way that you can actually bind an employee and stop them from speaking about it at the moment. But back to the proposed changes, what effectively the bill will do is add in a new section or a new personal grievance to the section 103. And that is a section that effectively will focus on the Employment Relations Act, all the personal grievances under that act. And if an employer decides to engage in any kind of conduct where the employee, discloses their remuneration, then the employer cannot go and say to the employee that, look, you're going to be sent down a disciplinary route or whatever it is. So if the employee goes through and actually goes through disciplinary and they decide to raise that personal grievance, then that is fully within their right according to that section 103. So where are we at with this now? It's quite an interesting space because this piece of legislation, or this bill, was first picked up by the Labour government in 2022. It has been kicking around, and I really didn't think it would actually make its way through, to be honest. I did an episode about this many, many, many months ago, and I was surprised that this wasn't dropped along the way, just because it doesn't fit in line with some of the coalition's agendas. But they have said that they are moving this through, and we'll see where this kind of goes. But right now, it's actually the Parliament's Education and Workforce Committee. They asked for submissions up until the 23rd of January this year. So we're obviously now in Feb. So we'll see where this kind of goes and what comes out of that. But there is, like I said, a lot of momentum, a lot of discussion online, and just, we'll see kind of where things are headed. Now, the last thing that I wanted to chat about, we're actually breezing through this, Bernie. So, we'll see how it goes. I might get through the questions, and if anything else pops up, we can have a little bit of a chat too. But the last thing that I wanted to chat about was actually minimum wage increases. So minimum wage is going to go up this year, as it has done in the past. What we've seen with the coalition government is a very, very a minor increase each time. They're trying to do a more conservative increase rather than going in full throttle, which is what we've seen in the past. And what to give a bit of context and background, what usually happens in these scenarios is that the Ministry of Business, Innovation and Employment, they provide their kind of 2 cents around what they believe the minimum wage should be based on economic circumstances, based on the climate at the moment, what the job unemployment rate is, what job seeker is like, and all of those things. They've taken all of that in, and they provide their recommendation. They recommended 2%, and the minimum wage is one of those changes that's definitely happening, but the coalition government has come back and said that they've done a review, and based on the economic circumstances, they have recommended a 1.5% increase. So mark your calendars, to everyone. From the 1st of April this year, we will see a slight 1.5% increase of the minimum wage. The adult minimum wage will go from $23.15 per hour to $23.50 per hour. Then the starting out and training minimum wage will go from $18.52 per hour to $18.80 per hour. I remember when I first got into employment law in New Zealand, and it was like, I don't know, $12 or something like that, or less than that, maybe $11 or something. So this is crazy to see how much this has changed over the years, over like almost the better part of a decade. So it will be interesting to kind of see under this government what next year will be like. But since we have a little bit of time, I wanted to give a little bit of information around what you can do to kind of prepare for this, because I always find this a bit of an afterthought for employers, and rightfully so. You think, oh, well, this is great, everyone's getting a bit of an increase. But what I have personally noticed is that in the workplace, if people are getting increases, there's a lot of chatter that happens, and it's usually people that are on the minimum wage or just hitting that minimum wage that you want to bump up slightly. One, because the minimum wage goes up, and also because you want to just make sure that you're keeping up with compliance and you're kind of keeping them rolling in terms of their experience. Now, because of the chatter in the workplace, what ends up happening is other employees might feel like they deserve an increase as well, because they're not really understanding the exact reasoning behind the increase. So with that said, I would say just make sure that you kind of brace yourself and you're prepared for that. I notice this a lot more in smaller businesses than in larger businesses, and my experience has predominantly been with small business. Obviously, I've helped larger businesses, but I've always got a soft spot for small to medium-sized businesses, and I know that it can be a huge pain point and it can be a huge issue. So I would say just prepare, brace yourself. The best way to do that is firstly making sure that you've varied everyone's employment agreement. It doesn't have to be too onerous or crazy. Send out those minimum wage increase letters. Let everyone that's getting an increase know that this is coming and that this is happening. Keep it on their personnel file. A lot of people forget to do this. And I remember having a client once say to me, what's the point? It's a beneficial thing. Everyone's getting an increase. So why do I need to let these employees know? And at the end of the day, you are varying their employment agreement. You are effectively changing that amount of money. And while it might not be a negative change, it still needs to be documented somewhere, just from a payroll perspective as well, and to cover yourself off and to create that transparency around what they're actually getting. So I would always suggest that, and to make sure that you kind of have that ready to go, and that letter to the employees, keep it on their file. And if you have a lot of employees discussing and speaking about their pay in the workplace, especially around the minimum wage going up, then you can absolutely speak to them. There is obviously, this is more on the HR front more than the employment law front, but there are ways that you can navigate around, chatting with your employees and speaking to them about the fact that, look, everyone's salary is not increasing, or wage is not increasing because of this particular reason, but it's just about making sure that you've kind of gone in with a little bit of a strategy. So if you need any help or pointers on that, we have certain information on our website and all of those things, and I'll speak to Bernie and see if we can find anything that around the minimum wage increase, because we always put out fact sheets and content around that time. So I'm sure I've come across something in my time here. Well, we've got about 20 minutes left. So what I will do is I will kick things off with looking at the Q&A portion. I think we've had quite a lot of questions coming in from what I could see. So I'll just pull it up now. Bear with me. All right. So what do we have? Okay, so we've got the first question that's come in, and that is around the dismissal threshold being, that 180,000, whether that includes their base salary or other earnings and other benefits. So I know I mentioned it a bit late in the piece, so I apologize, but yes, it is only to do with their base earnings. So basically, the base earnings would be 180,000. That is what would be written in that remuneration section of the employment agreement, and it would not include any allowances or anything in addition to that. And I like that we've actually got a lot of time. Bernie, I hope you're liking this too. Give me a thumbs up somewhere if you're enjoying this. But I'm glad that we've got a lot of time to go through this, because usually it's a mad rush and we've got like 2 minutes. So the next question that's come up, which I think we'll get through all the questions, but let's see. The next question that's come up is around we will need whether we need to follow, or employers need to follow, any type of process if we need to exit an employee that's earning over 180,000. Look, this is going to be hard for me to say as a lawyer, but the reality is in Australia, even, you ideally you don't need to do a full-blown process or anything like that if the person is earning over that income threshold. In Australia, like I said, it's 175,000. But what I have noticed more and more when we implement these kinds of changes, and what I have seen in Australia as well, is that having some sort of process in place. So just something. Let's say you've had a simple discussion with the employee around performance. You might be catching up with them regularly, one-to-ones or something like that, and having a chat to them about their underperformance and things are not getting better. One, that sets the scene for something not coming out of the blue. It also, in good faith, is the right thing to do generally. But two, what it also allows you to do is, off the back of that, branch off into a process where you say to the employee, look, I'm going to give you this time to improve. If you're not improving, we're going to have to look at terminating. And you can set out those parameters very clearly and follow that process. And the reason why I say a process is a lot better than just pulling the trigger and going, you're out, is because at the end of the day, you need to still protect yourself from other types of claims, like discrimination, like any kind of other disadvantage that might come up in the workplace, or anything that might have been done in the workplace around, sexual harassment or anything. So you just want to make sure that you're not going down that path. And the only way you can mitigate that risk is by having something well documented enough to show that no, this was nothing to do with you and any protected characteristics or any adverse action related stuff, like what we call it in Australia, that anything related to that. No, it's not related to that at all. It's actually more about the particular job that you're doing in terms of underperformance. So that's where the conversation would come up. I know I've heavily focused on performance, but that could be anything under the sun. It could be disciplinary as well. It could be, whatever it is. And to be honest, it'll be interesting to see how this comes up, because we see a lot with toxic employees. We see, we like to use that kind of terminology, but it'll be interesting how that works when you have a manager or somebody so senior where this comes up and you want to move them along. In Australia, you can have that conversation with them, move them along, but we'll see what other parameters there might be in New Zealand as this kind of progresses. So that was very long-winded, but I hope this gave you a little bit of a setting the scene in terms of the way Australia approaches it. And so what does it say? So I see somebody messaged around the dismissal. So they said that, look, it's a bit strange at the end of the day, because being dismissed due to lack of performance wouldn't be unjustified. Unjustified would be if the person was performing well, but still gets dismissed. Well, the problem and the reason why it's unjustified in New Zealand, and the reason why somebody can raise an unjustified dismissal claim, is because there's a two-prong approach that you would take to your terminations. And Bernie and I are talking about doing a termination webinar. So we're very excited because we're thinking about this. So if anyone's interested in it, actually in the chat, feel free to add in if you'd want to see a terminations related one. But the whole idea behind it is that, look, if you want to terminate somebody, then you need two prongs. One is that you need a good justification, and you need to follow something procedurally correct. And if you fail in one of those areas, so you don't provide a good reason enough, like let's say you think that they've stolen something in the workplace, but all of a sudden, the CCTV footage actually is a bit blurry, you can't really tell. So that causes a bit of an issue. Or let's say that your process isn't followed correctly, then that is where there creates issues for a personal grievance to come up, because the employee can effectively claim that, no, this was unjustified, you didn't follow the correct process. And the same thing goes with performance as well. No, you didn't actually meet with me, you didn't consult, you didn't put a proper PIP in place, things like that. So that's where it can go down the path of, hey, this is actually an unjustified dismissal, and you shouldn't have done this. So that is that's kind of the reasoning behind that. So hopefully that's helped. And somebody said, do we need to do a variation for all staff earning 180,000 or more to include the unjustified dismissal protection? Yes. So if you wanted to have basically, once you negotiate with your employees in that 12-month period, effectively, look, this is what it's saying right now. We'll get more information as this plays out. But for what we know right now, if you're having a chat to your employee, once the law goes through, do not have the discussion now. Once the law starts going through and we know that it will land by this date, then that's when you have that 12-month period. Chat to your employee, see if they want to opt back in and have that included in there, bargain with them. I think it's going to create a huge bargaining issue, but let's see how it goes. But they're automatically opted out, and there has to be an agreement reached by both parties. So like I said, the unfair bargaining thing might come up, and in these situations, it will probably be a variation that will need to be made to the employment agreement. I can't see the need to change the entire agreement. But if you've got a lot of old clauses, we always say, do a refresh then if you want to. So a lot of other questions around the 180K threshold. Sorry, everyone. Usually, we've got a couple of us on here, so that it makes it a bit easier, but let me wade through this. And so so somebody has asked, and rightfully so, a question around can they challenge their dismissal through other channels like the High Court, or how does this compare with Australian legislation? So we don't have the same structure in New Zealand as Australia. So the way that it would normally go through is that, let's say, and we're just talking about unjustified dismissal claims, in those scenarios, then it would just go through basically a mediation. You try to settle it there. If you can't, then it will go through the Employment Relations Authority, and only after it's gone there and there's a lot of merit and you want to take this as far as it can go, will it go to the employment courts. So it doesn't follow the same structure where you can just jump straight through to the High Court or anything like that. There's always process to revert you back to mediation, for the most part. So that's generally how it will go if there is any kind of concern around whether this was done correctly. But again, we'll have to see what pathways get created and what kind of comes up as the law goes through. So look, one of the questions that came up, and I know that this is a huge topic of conversation in New Zealand at the moment, is how are you sure that an employee won't just get terminated on the spot if they're earning 180,000? I can't guarantee that, and no one can. And that is the reason, and this is the crux of the reason why the topic and the discussion has been going on for such a long time, and everyone is so upset about it, is because these high income earners are kind of not able to access justice effectively. And so that has become a huge topic and a huge issue. So another question that's come up is around, so whether there's thresholds to be applied for exit discussions. With the exit discussions, if you remember what I said before, that you can have the conversation with the employee and see if they'll agree to a settlement, and you're kind of not going to be in hot waters for an unjustified constructive dismissal claim. In those scenarios, it doesn't seem like there's going to be a threshold at the moment, but we'll see as this kind of goes ahead. But right now, no threshold. You can have it with anyone. But like I said, having that conversation won't be easy. I think it will still be a tricky one. So we'll see kind of where it goes with that. Now, so what has this said? Do you think that the government, sorry, everyone, just reading as I'm doing this. So somebody asked about paying for the restraint of trade. Like I said, in the restraint of trade, with the proposed changes that they're suggesting, one of them is that you'll have to pay the employee for the period that they're restrained. You'd have to pay them half of their weekly earnings. And this would be effectively, the person's asking, when does this get paid? Only if they're enforcing it at the end of their employment. Is it a lump sum? We don't know the exact details yet, but from what I understand, it will be effectively like you would be keeping the employee on your books for that entire period and paying them like you would, be paying them normally. But I understand where the complications arise, because it's like, okay, now they're accruing annual leave now and doing all these things. So as this pans out, I'm sure we're going to get a lot more detail, but I believe that it will effectively be that. But maybe there could be a lump sum approach by reaching agreement with the employee. We'll see how it kind of goes through after it's, we get the feedback back from the January consultations that were done. So which ones are bills and which ones are just proposals? Which ones do you think will be passed, etc., and when? So all of the ones that I discussed today, except for the minimum wage increase, those are all bills, which means that they are all still proposed, and it is going through the houses, and we're working our way through to see what's going to come up, if they get enacted and if they progress through. So personally, for me, I don't know. Look, I can say that the coalition government is going to push through and they're going to do this, and this is what it's going to be. But at the end of the day, it also depends on the houses and the committees. It also depends on public, consultation, targeted consultation. If everyone's saying that this is the worst idea ever, then that's going to have a huge impact. So we'll see based on public perception as well, rather than only just focusing on what the government wants. And so somebody asked if there's an obligation to increase basically when you increase minimum wage, if you have to increase it across the board for everyone. And At the end of the day, look, there's no obligation to do that. And like I said, it's a common misconception in smaller businesses that you have to increase for everybody. You don't have to, but having those conversations and being able to craftily have those conversations will be very important and very critical. I am no HR expert and HR guru, but I will speak to Bernie and see what content we have around those conversations and see if we can send something through after the webinar and our post-webinar materials. But it is, yeah, it is not a requirement for you to raise everyone's, salaries or anything like that. With the minimum wage, though, what I will say is just make sure you've checked your employees that are on a salary, because a lot of times you don't realize, but they're just hitting that minimum wage threshold. So make sure that you've actually checked that and seen if you should bump them up or not, because you just don't want them to be working additional hours and all of a sudden they're saying that they're taken below the minimum wage threshold. So make sure right hours, they're at the right wage, which equates to their salary. All right, let's see what else we've got in here. Sorry, I'm just trying to field through some of the questions that sticking through to the topics that we have. All right, I'm just having a look through. A lot of these are still on the 180K. This is a good question. Is $180,000 threshold calculated pro rata if they are part-time? Again, this was something that we haven't seen too much information on, but as this kind of progresses, then we will see what comes out of this. And what else do we have? So somebody said, what's the validity of the restraint of the record of settlement in these conversations? I'm not entirely sure which exact bit you were talking about, but if I can go back, let's see if I can place myself well. I'm pretty sure we were talking about the maybe the exit discussions. If with the record of settlement and with the with those records of settlement that you would sign when you're doing exit discussions, yes, they still have validity. They will still you still reach an agreement, and that's the whole point of these particular exit discussions that you would be doing. So that's not going to stop that or inhibit that from being something that you can actually rely on and let it kind of and use. But it's more so around, I'm just wondering how are these conversations going to come up if the employee says, no, I actually don't want to go through with this, and I don't want to reach a settlement with you. Sorry. So that is where I'm a little bit skeptical. So we'll see how this goes in practice. And a lot of these things, and I think a lot of times what we don't realize, lawyers love to say it, is that this hasn't been tested. We have to kind of see what kind of plays out and what happens. And it's true, until a case goes to the Employment Relations Authority or to the courts, like with Uber, that's been there 5 million times, we just won't know the outcome until we get that final result. Because I guess Uber's the best example. 1 minute they're employees, 1 minute they're contractors, and then you're kind of just going back and forth. So I'll get into so somebody asked if there's been any entitlement changes for redundancy entitlements, like what there is in Australia. No, there hasn't. No discussion around that. And I'll see a couple of more questions. I know we've got to wrap it up soon, but so this person said, so somebody has asked around the living wage and what that will be and if that's going to go up this year. Look, to be honest, what I've actually seen is a massive shift with other areas. I know that we didn't touch on accredited employer work visas or anything like that, but what we have seen is that there's been a huge shift. Before, it used to be the median wage, or they would rely on that median wage off of the living wage. That is now changing significantly, which makes me believe that the numbers that we're going to see are going to be like lower. We're not going to see massive jumps with the living wage, but I don't know entirely. But from what I can see with those indicators, like I said, with the accredited employer work visa, the wage now that you will have to pay is either industry standard or it will be at least the minimum wage, which is a huge difference to $29 or whatever it is at the moment. And I'll just have a look through again just to see if we've got anything else. Mm. So again, people asked about the total remuneration, whether that's going to involve the cars, KiwiSaver or whatever it is. It will just be what your base salary is. So if your base salary shows that it's 180K, then that is what it will be. No car included or anything like that. And again, let's see if we've got anything else. I know we've got to wrap up soon. I'll just quickly check the time. Okay, a couple of minutes. What else do we have? 12 months. Yeah, so again, people asked around the 180,000 and what about 12 months? If employees are on that 12-month period and they earn above 180,000, 180,000 is the base threshold again. So that is the minimum they need to be earning to be opted out of the personal grievance regime. You need to opt them back in. If they reach a negotiation and bargain with you and you agree to it, then that's when you would opt them back in. But otherwise, they would be, it doesn't matter if they earn 190, 200, whatever it is, they can still, you still be part of that whole system and regime unless they opt back in. So yeah, 180,000, that is the base. I'll do one more question. See what else. So somebody asked if we've got another. Oh, well, Bernie's answered it. Bernie's onto it. Okay, I'll do one more. This is actually not related to this webinar at all, but I thought that this was a really interesting one. And for all of you sticking around, because I can see that there's still, a couple hundred of you still here. So one of the questions was around the risk of not having a 90-day trial period clause in new agreements. I know that this is not the topic of today, but for anyone out there that just wants a bit of a refresher, the main thing is that the 90-day trial period is there effectively to help an employer be able to assess the suitability of an employee and move them along if they're not matching, the skill set, the suitability, whatever it is in the workplace. If you don't have that in your employment agreements, maybe you have a probation period clause, maybe you don't have anything in general, the risk is that you're going to have to go through a full-blown process and a full-blown, disciplinary performance process, whatever it is, to actually terminate them. So that means that it will take up a lot more of your time, a lot more effort, and you'll probably have a longer notice period as well. So having a trial period will actually really help. Now, the one issue is that over the last better part of a decade, 75% of cases that went to the Employment Relations Authority around trial periods failed. So out of 100% that went, 25% were only successful, 75% failed, which means employers get this wrong time and time again. Please feel free, for anyone that's kicking around and hanging around here, feel free to check out, my LinkedIn. Like I said, with the podcast as well, I talk about this in great detail. Employment Hero talks about this in great detail around how to get the trial periods right. So absolutely tap into that resource and definitely use it. And so with that, I guess we've breezed through a lot of these questions. And I'm glad that a lot of people found these very interesting. And I believe that we don't really have anything left that's quite substantial. So I'm glad to say that you guys made it through to the end. Thank you so much for sticking through my annoying voice. And I really appreciate your time, for lending me your ears and your eyes. So thank you so much, everyone. I hope you have a lovely afternoon. You get some delicious lunch. And for me and Bernie, thank you so much for making this another awesome webinar. If you've got any other questions, like I said, reach out, have a chat, and we'll be sending through the recording and all of this information to you afterwards. So take care, everyone, and have a lovely day.